Hi, this is Rick Durfee with Durfee Law Group. I'm here to make up for something that we did this last week. I spoke at an event with the College of Estate Planning Attorneys here in Phoenix and addressed specifically the use of alternative dispute resolution in estate planning. And we tried to record it, it didn't work. So I'm here in my office. This is not my office behind me here, that's a background. Uh, and our recording did not work. So I wanted to see if I could duplicate some of what we talked about because it was pretty powerful. Uh, Alternative dispute resolution in estate planning is something that seems like a new topic. In fact, recently, recent in terms of what happens in estate planning, which can go over centuries, but relatively recently, a number of states, and I think the count is now up to 34 or 35, have adopted the Uniform Trust Code. And as part of that code, there's actually a specific provision that recognizes alternative dispute resolution. And the code basically says a trust or a will or things like that are allowed to have alternative dispute resolution procedures built into them. And so here's the question that I posed to this group of college estate planning attorneys, which are all very knowledgeable and reputable and highly qualified attorneys. So multiple quiz, multiple guess question here. So this statute that addresses the issue of alternative dispute resolution in estate planning, here's the question. Number one, or A, it introduced the relatively new idea of alternative dispute resolution to estate planning. Or B, it made it possible for estate plans to incorporate alternative dispute resolution into the documents. Or C, prior to the enactment of this statute, a trust or a will that had alternative dispute resolution could not do it. But after the enactment of the statute, a trust or a will could include alternative dispute resolution. Or D, all of the above. Or E, none of the above. And I posed that question to the group, and I kind of expected this because it was kind of set up that way. The group answered almost unanimously D, all of the above. And the real answer is E, none of the above. And here's why, and something that is really crucial to understanding trusts and what they are and how they work. Unlike business entities like a corporation or an LLC, which arise by virtue of a statutory grant of authority, trusts, on the other hand, arise out of the natural rights that people have to deal with their own property. And they can contractually agree to do anything with their property that's not otherwise against the law. So you can't agree to commit a crime, but if you're not committing a crime, you can do anything you want with your property. And obviously, if it's real estate, you have to obey zoning laws and things like that. But within the bounds of the law, you can contract to do anything with your property, including create a trust. And so trusts we don't need the permission or a license or a grant of authority to form a trust. They're not created by virtue of registering them or filing them with their state. They're created when certain contractual provisions are met. And in fact, statutes like the Uniform Trust Code exist because lawyers who create trusts are notoriously bad at putting in the things they need to in the trust. So trust documents are defective or deficient or silent on critical questions, and those questions end up in courts, and courts need or want guidance. They want cover. Well, if we're going to resolve this question that comes because a trust is ambiguous or silent on an important issue, it helps the courts if there's a statute that says, well, if the trust doesn't address this issue, do this. So statutes in estate planning in particular arise not as a grant of authority or permission, but to fix lazy or lousy practices by lawyers, which comes down to well, what's this thing with alternative dispute resolution? And in fact, when did alternative dispute resolution begin in estate planning? Is this a new thing? Because it's kind of feels new, especially with younger lawyers that haven't been around for very long. It feels like, ooh, the traditional way of resolving a conflict or a dispute is you go to court and you ask a judge. We can't solve this among ourselves. So, judge, we want you to solve the problem for us. And the parties submit their issue to the court. And if there's differing opinions about how it should be, the parties make their arguments and the judge renders a decision. Well, has it always been that way? And I was tempted in my meeting to begin at the dawn of time, from the earliest points of creation, and go through all of these iterations of when and how alternative dispute resolution have been applied. And there's actually some very interesting history with that. I skipped that, and I'll skip it now again. And I'm going to come, in fact, to some events in what came to be called the New World, which was separate from the Old World in Europe, where all kinds of innovation and interesting things were happening, and where we recognized a legal system that acknowledged that there are inalienable rights, and that property rights, the ability to deal with our property, are foremost among them. And we have a tremendous history of how this new world invented or embellished upon old legal structures to invent new legal structures. And as it turns out, the man who's sometimes called the founding father of our nation, our very first president, George Washington, incorporated an amazing term in his personal will. This is so amazing. I want to read it to you because it's really cool. So here's a quote from George Washington's will. Having endeavored to be plain and explicit in all devices, even at the expense of prolixity, perhaps of tautology, I hope and trust that no disputes will arise concerning them. But if, contrary to expectation, the case should be otherwise from the want of legal expression or the usual technical terms, or because too much or too little has been said on any of the devices to be consonant with law, my will and direction expressly is, here's what George Washington wanted, pay attention, that all disputes, if unhappily any should arise, shall be decided by 3 impartial and intelligent men, known for their probity and good understanding, 2, to be chosen by the disputants, each having the choice of one, and the third by those 2, which 3 men thus chosen shall, unfettered by law or legal constructions, declare their sense of the testator's intention, and such decision is, to all intents and purposes, to be binding on the parties as if it had been given in the Supreme Court of the United States. Close quote. Now I want you to think about this. This is actually pretty astonishing. This is a country where new laws were being formed. And the whole idea is, if it's not prohibited by law, we can do it. That's what liberty is all about. And in fact, a free people can do as they please with their property. It's only where we're not free that some sovereign government authority or bureaucrat has the power and authority to tell us what to do with our stuff. So George Washington wanted any dispute that arose concerning his estate to be decided unfettered by law. Think about that. Don't do what the laws of man can be screwed up. They can be wrong. So just do what's right. By the way, that whole idea is rooted in the notion of natural law, which is the idea that there are some things that are right and wrong. There are laws which are natural, which exist independent of whether we understand them or know them or follow them or not. And the goal of human law is to figure out what those natural laws are and then embody them in our code or in our judicial decisions. That idea of natural law has largely been abandoned by the legal community in favor of the law of social contract. Well, the law is anything we agree it is, and there's no such thing as a good and evil independent of the law. It's good or evil if we say it's good or evil. That's the kind of the modern philosophy, but the ancient philosophy it was older than that, and that was actually the foundation of our nation. Believed in natural law and the idea that we could identify what is right and wrong, independent of what the formal laws of the land may say, and that's what we should do. And that's what George Washington wanted, and he built it into his trust. So from that day to this day, really good estate planners have employed alternative dispute resolution in wills and trusts. They have said, yeah, we don't want to go to court. Going to court is not healthy. It's not good. In fact, it's been my experience professionally that when a family goes to court, everything blows up. And even if one person gets more money than they might have otherwise gotten, the family as a unit is destroyed by litigation. So litigation is not healthy in an estate or in the administration of an estate, and we want to avoid it. So enter then alternative dispute resolution. And I want you to think about alternative dispute resolution as something bigger than just, oh, we would have asked a judge to do this, but we're not going to do that. Instead, we're going to solve it outside of court. Alternative dispute resolution is anything we do that reduces the risk of a dispute or a conflict. And so from that perspective, I'm going to give you six things that lawyers can do to reduce the risk of litigation in estate planning. And this was targeted, my audience when I gave this presentation was lawyers, but I think even other advisors, other professionals, or even potential clients or existing clients of the firm might want to think about this. So here's the six big things that we can do as legal practitioners to reduce the risk of disputes and conflicts in our estate planning documents, our wills and trusts. And here's big thing number one: better drafting. Better drafting. Remember what I said earlier. Often statutes are implemented to compensate for lousy legal work. So stop doing lousy legal work. And let me give you a very specific example. I review hundreds of trusts every year, and chronically I see trusts that are written that refer or depend upon or defer to local state statutes. So they'll say something like, the trustee shall have all the powers set forth in, and then they cite a state statute. And that's it. That's the extent of the trustee's powers. Now, why is that a bad idea? It is a bad idea, by the way. It's really a dumb idea. It's lazy, poor practice on the part of an attorney to do that. Why? Why is it dumb? Why is it bad for the client? Well, several reasons. If the trust is dependent upon the statute, then it is vulnerable to the political process. The politicians made the rules, and they can change the rules. And guess what? They will. The probability of change in the law is 100%. And so a question we have to ask is, are the new rules we get when the politicians change the deal going to be better than the old rules? And you can figure that out for yourself. Some people say yes, some people say no. So don't depend upon or defer to the code. The code is there to compensate for lousy work. Don't do lousy work. Do the good work. You figure out what the trust should say. And in fact, often what the code said is not in the best interest of the client. It does things the clients don't want. So you should be figuring out that stuff yourself. You're the lawyer, you're the professional. Think through the issues and craft a trust instrument that does what you think is best for your client. And, I'm going to say another thing here on drafting better documents. It's been a trend that I've observed in estate planning generally, that lawyers no longer own their documents. They rent them. They subscribe to a service where they can get their documents from a group of really smart lawyers. And frankly, the documents they get are very good. Some of these documents I've reviewed, and you go, wow, that's a well-crafted instrument. Here's the problem when lawyers don't create their own documents. This is what I've observed. Lawyers will put out documents that they bought from a service and they have no idea what they do. You ask them, well, what does this mean? And they go, oh, I don't know. It was just in the form. Or why did you include this? Oh, I'm not sure why that's in there. I just clicked a button and it showed up. That is not being a good lawyer. That's being a lazy order taker who fills out a form online. You're no better than the client that goes online and buys a do-it-yourself form. If you're just going to click buttons that you don't understand and put provisions in a trust that you haven't read and you didn't develop and you don't know how to use or how to explain to your client, you're not being a real lawyer. Be a real lawyer. Draft your own documents. And even if you're going to rent documents from a service, do your client the courtesy of actually reading them and thinking about, well, is this good for my client? Is this what my client wants? Does this fit my client's particular circumstances? So don't defer to the codes. Don't rent your documents. And here's now big thing number 2. Don't default to the courts. I'm going to tell you, this is a true story. I know I have to give this disclaimer with respect to all my stories. All my stories are true, or at least mostly true, but they have been editorialized to protect the privacy of my clients or to make the point a little bit or to make them funny. So this is a true story. I was in a continuing education seminar for lawyers, and some highly reputable lawyers were speaking. And these were lawyers whose practice, by the way, even though they were in the estate planning arena, they were technically, they were litigators, and they make their living by going to court. And so this lawyer was talking about some esoteric, difficult provision in a trust, and I can't remember what it was anymore. That was not the point. And the lawyer, who happened to be a woman, it doesn't matter, she said, this is such a complicated question. If I present it to my client won't understand it. And if I tell my client what I think they should do, it will be hard to convince my client to do the right thing. So this is what I do. I leave it out. I just don't address this issue. And then when the client's dead, we can take the trust to court and get a judge to tell us what to do. And the judge will make the decision. And at the moment, then and now, I was horrified. You're telling me that you're leaving a critical component out of the trust on purpose because it's hard for your client to understand, and you're going to fix it by going to court? What a terrible thing to do to your client. What a bad way to practice law. Don't do that. You are the lawyer. Think through the tough issues. Come up with what you think is the right answer and build it into your trust and explain it to your clients so that they can understand it. If it's right, your clients aren't stupid. They can understand. Explain it to them. In fact, the mark of intelligence is the ability to explain complicated things to other people in a manner that they go, oh, that makes sense. I understand. If you can do that, you're a good lawyer. You're intelligent. If you can't do that, you should be doing something else. So do the hard part. Do your work. Actually think through the issue and craft a good trust document or a good will that addresses the issues. Now, here's big thing number 3. I include a clause in my trust that basically says if there's a question about the meaning of this, if there's some ambiguity or something that is unclear, the lawyer who drew up this trust may render a written opinion as to its meaning and interpretation, and that opinion is binding upon the parties. This is powerful. It is. We do our best as lawyers, following number 2, we do our best to think through the issues, to write clear language, to make it so it's understandable, so that there's no ambiguity. And in spite of our best attempts to do that, we are still frail mortals with limited capacity. We're not gods. We don't have omniscience or the ability to see into the future. So things come up that we didn't expect, and people read words and go, wow, that doesn't mean what you says it means. It means something else. And frankly, plaintiffs' lawyers will look for those and seek to exploit any ambiguity they can find or project onto the words in order to get some advantage for their client. So having the ability to say, okay, I don't think that's ambiguous, but you say it's ambiguous. So here's what we're going to do. I'm going to render a written opinion as to what that means, and it's binding. I've employed that over and over and over again. And often there are little disputes, or not even a little dispute, just a little question in administering the trust. The next generation or the trustees go, hey, I'm reading this and it doesn't make sense to me. It could mean this or it could mean that. What does it mean? And to be able to say, oh, yeah, okay, I see your point. You brought up something that 15 years ago when we wrote that document we hadn't thought through, or we were unaware of because the laws changed or the facts are different than we would have guessed. So here's what it means. Here's how we interpret that. We put it in writing. This is a binding interpretation. By the way, that is really effective at avoiding and resolving conflict, because when it's a manufactured ambiguity that a plaintiff's lawyer is injecting into the document so that they can squeeze something out of the party for the benefit of their client, we can say, you know what? Yeah, that goes away. It's not ambiguous. It's not unclear. So that's big issue number 3. Here's big issue or big thing number 4. Big thing number 4. Use a trust protector. Now, a trust protector can be a lot of things, and this is kind of an area of the law which in the minds of some people is still evolving. It's actually ancient. Protectors have been around for a long, long time. They're as old as trusts are, thousands of years old. They've been used offshore trusts for a long, long time. I was using a trust protector back in the 80s and the 90s. And I've used them ever since, before they were ever recognized by statute. The same thing happened with trust protectors as happened with alternative dispute resolution. With the Uniform Trust Code, there was a statute that said, hey, you can have a trust protector. Now, did that introduce trust protectors into the practice of use in trusts? No, they were there before. Did it make it possible to have a trust protector because the statute acknowledged it? No, you could do it before. It's just finally the statute caught up with the rest of the world. In fact, the statute was dealing with, once again, lousy legal work by lawyers who didn't do their job and who didn't know what you could do it. And astonishingly, in fact, I'll tell you a story. By the way, you need to know what a trust protector is. A trust protector, in my opinion, and again, there's some other views of this, but a trust protector is a third party, not a trustee, and in my opinion, should not be a fiduciary because they don't touch the assets. So the trust protector never takes possession of the assets, and the trust protector's duty of loyalty is not to the trustees, and it is not to the beneficiaries. It's to the trust and the intent of the grantors. So that's what the trust protector's duty of loyalty is to. And you can have the trust protector and you give the trust protector some powers. The trust protectors can sometimes modify the trust if there's been a change in the law or circumstances that makes some element obsolete or punitive because we're using it. The trust protector can often do things like fire a bad trustee. So you have a trustee who files bankruptcy or goes to jail or moves to Australia and won't return our phone calls or just doesn't do their job or is stirring conflict up in the family. The trust protector can say, yeah, you're fired. Who's next in line? And then get a new trustee. So trust protectors can also do fabulous work in terms of managing conflict and helping the parties come to a resolution. Okay, the trust didn't have this in it. It should have had this in it. We didn't know the politicians were going to change the rules. They changed them on us. We need this new provision. The trust protector can, if they meet all the qualifications, stick that new thing in the trust. So some years ago, I had a trust drawn by another lawyer that had a trust protector provision in it. And a third lawyer was hired by the family after somebody had died and said, I don't like this trust. It really stinks. It does one thing and I want it to do another. And we're going to sue everybody to make it happen. And I said, well, why don't you use the trust protector? And this third party lawyer who was a litigator said, oh, you can't do that. That's not allowed. Show me in the statute where it says you can use a trust protector. And there was no statute at that time. So I said, yeah, dude, come on. You think you have to have permission from the statutes to contractually decide how you're going to manage your property? No, you don't need a statute. This trust has a trust protector in it. You can follow the provisions of the trust. So with this plaintiff's lawyer all the time nipping at my heels, telling me I'm an idiot, saying, oh, you're stupid, it won't work, you can't do that, it's against the law, it's going to cause problems, and calling me bad names and insulting me in front of the client, I said, yeah, okay, shut up. Here we go. And we're going to make this modification of the trust to fix the problem. And so we did. We fixed the problem. Now, amazingly enough, a year later, that very same lawyer who had told me I was an idiot for using trust protectors was advertising continuing education seminars on the use of, guess what? A trust protector. So suddenly he went, this plaintiff's attorneys just have this problem. Suddenly went from telling me I was an idiot for using this to claiming to be a genius because he came up with this really good idea. This is such a cool idea. I'm going to go out and tell other lawyers how to use it. Trust protectors, they can solve a lot of problems. Big thing number 5, make alternative dispute resolution procedures mandatory. Make it necessary. Now, for it to be necessary, it's got to have teeth. There's got to be penalties if you violate it. Let me tell you what my penalty is. You're going to follow the alternative dispute resolution procedures outlined in the trust, or you are automatically and immediately removed from the trust for all purposes. You get nada. If you're a beneficiary, you're treated as if you're dead, as if you died before the grantors. If you're a trustee, you're fired. You're out of here. Now, sometimes, in fact, I'll share a case with you. And again, this is one of those true stories where the facts have been modified to protect the privacy of my client. I had a situation where a lawyer in another state, not my state, got one of my trusts and represented a trustee and decided, well, and there was a conflict, a dispute. In fact, the trustee, who was also a beneficiary, decided to interpret the trust in a manner that was radically in favor of that trustee and against the interests of all the other parties in the trust. Go figure. Who would ever do that? What? I would read this trust to my advantage and to your disadvantage? Well, they did. And they went to a lawyer and said, hey, can I do this? I think I can rip off my siblings and get more money by interpreting the trust like this. And the lawyer said, yeah, I think you could do that. Well, I wrote a letter because they asked me, said, hey, we're going to do this. And I wrote a letter and said, hey, there's mandatory alternative dispute resolution procedures in this trust. If you violate them, you are removed. Don't violate them. And other parties to the trust dispute what you're doing. So this lawyer wrote a fancy letter telling me, once again, Rick, you're an idiot. You don't know what you're talking about. Alternative dispute resolution doesn't apply to us. We don't have to follow that. Yeah, that's somebody else. It's not us. We can ignore that. And they did. And in fact, they brought a lawsuit in this other state. And they didn't tell the judge all the facts, which really irritated the judge later on. They only told the judge what they wanted the judge to hear. And the judge entered a ruling. Whereupon, I happened to be the trust protector in that case. I said, okay, guess what? You're removed from the trust. You're not the trustee anymore, and you're not a beneficiary anymore. And of course, the client, the trustee beneficiary went ballistic, and their local lawyer went into the same court in this other state and filed a petition to prevent the trust from removing this person, which it said clearly by its terms that would happen, and a motion for sanctions against me, because how dare I, as a lawyer, do anything that contradicted the judgment of the court. So I happened to be on vacation when this happened. I was at a South Carlsbad Beach in California, and with my cell phone, I found a highly rated, really good attorney in this local jurisdiction. And within a few days, and without very much money, we had a motion to compel arbitration. And the judge, and I read this language in the College of Estate Planning Attorneys. I'm not going to read it here, but I'm going to basically say this. This is what the judge said. This is what the judge said. The judge said, actually, it was a woman. Well, the judge said, she said, hey, you got this judgment by misleading me. You didn't tell me all the facts. You didn't tell me that there was mandatory alternative dispute resolution provisions in the trust. You didn't tell me there was a trust protector. And oh, by the way, your position that this does not apply to you is completely without merit. And your motion for sanctions against Durfee is completely without merit. Threw it all out, forced it into arbitration. Now, here's a question that came up. And in fact, this is something that often happens. Plaintiffs' lawyers will say, hey, arbitration, this alternative dispute resolution stuff, what a bunch of garbage. That's way more expensive than litigation. And it takes more time, and it's really bad, and it's really awful. here's what I experienced. At the same time that case was happening, where, by the way, I got a motion to compel, and we got everything thrown out. I sent that lawyer in another state a retainer of $2,500. I think I got a refund of like $600. So for less than 2 grand, we had it completely enforced. While that was going on, in another case, in another state, another lawyer who's a very good lawyer, a highly skilled litigation lawyer, did a motion to compel. It took a year, and the legal fees were more than $100,000. Now, which attorney was the better lawyer? If you ask the managing partner of the firm where this highly skilled litigator brought in $100,000, they would say, good job, buddy. Way to go. Yeah, do that again. They liked it. They thought it was awesome that he was able to wring 100 grand of fees out of the client. In my opinion, the litigator who took 100 grand in a year to get the job done was frankly not doing a good job, was not serving the client well, and was not as good as the lawyer who got the same job done for less than 2 grand. So get the right lawyer. The alternative dispute resolution procedures work. Let me tell you, in my documents, I incorporate an agreement that has 4 stages of alternative dispute resolution. And the goal is to resolve the conflict at the earliest stage possible. I'm going to go over this quickly just because it matters. And in fact, my agreement is called the Integrity Agreement, and I'll tell you why. I'm going to read the opening few lines from the Integrity Agreement. Integrity is adherence to a high moral code, a state of being sound, unbroken, and unimpaired, and the quality of being whole, undivided, complete, and united. Conflict and contention damage the integrity of both the group collectively and its members individually. So we want to preserve and maintain and build integrity, and we want to avoid things that break us apart, especially in families. So under this integrity agreement, 4 stages. Stage number 1 is communication. You have to give notice and tell people there's a problem. Hey, this happened or it didn't happen, and I don't like it. What are you going to do about it? And give people a chance to fix it. Astonishingly, when people find out, oh, I'm sorry, I didn't know that bothered you. Yeah, let's take care of that right now. And they fix it. It goes away. So notice communication, number 1. Can't be a closet victim or a secret martyr. Get it out there. Let people know, hey, this bothers me. Step number 2 is negotiation. And there's a process to sit down and work it out. I met recently with another client who's just got his PhD in organizational behavior, and he loved this idea. So here's the idea. One of the ideas in the negotiation phase. Each party under the negotiation phase has to say what the other party wants in words the other party will accept. So here's what we find. Often what happens in families is kind of similar to what happens in the political process. We're seeing today, this might date this video, but maybe this is universally true of all times, kind of a scorched earth approach to political opponents. All sides of the political argument in today's environment are saying the other side, they're the devil, they're evil, they want to destroy the world, they're going to blow us all up and put us all in prison and kill us all one way or the other. So it's all extreme, over the top, hate-filled language, which makes rational discourse and working through actual problems are really virtually impossible. And when that happens in a family, when we characterize the problems in extreme, hostile, negative, insulting terms, we're not working towards a solution. We're just exacerbating and perpetuating the problem. So we compel the parties to speak what the other side wants in language the other side will accept. And I've been through this many times with many families. And I've seen people coming in the beginning, well, what you want is, and they'll say some nasty, insulting line of argument. And the other side will say, no, that's not what I want. And finally, they'll come down to, so wait, let me get this straight. All you want is your fair share? And all you want is for people to talk nice and be polite? Really? That's it? okay, we can resolve this conflict on the basis of that. So I've seen a lot of conflicts go away because people, they're either speaking different languages, they have not agreed upon what their terms meet, or they're reviving or perpetuating sandbox rivalries and just being mean and nasty to their siblings because that's the only way they've known how to talk. And when you teach them another way to talk, hey, can you say that in a polite way? Can you say that in a way without calling your sister foul names? Can you say that in a way that like you were speaking to somebody that you actually respected and loved? Okay, say it nicely. And guess what? As soon as you do, the problem goes away. So step number 2 is negotiation. Step number 3 is mediation. With mediation, an outsider is brought in and they coach or counsel the parties to a resolution. Often that will be a subject matter expert, depending on what the nature of the conflict is. And the 4th and final stage is arbitration, which is like a trial, only private, faster, cheaper, and easier. And here's the thing. It works. It resolves the conflict. I over and over and over again, I've had families go through this process, and the vast majority of the time, it settles at a very early stage. It's very rare that it actually gets to arbitration. And in fact, when it does reach the point of going to arbitration, usually there's one side, often at the urging and coaching and advice of a plaintiff's lawyer. There's one side who's just intransigent. They just dug in their heels and no amount of evidence or facts or arguments is going to dissuade them. And you have to get to the point where somebody with authority to cram it down the throat, crams it down the throat. So that's the agreement I use, integrity agreement. By the way, the parties don't have to sign that for it to be effective. It's your property and your trust. You can say what you want. You can say, if you want to receive a benefit from my trust, you must comply with this. And if you don't, you're out. You can do that. So have penalties, have that ADR provision. Okay, big thing number 6. And this is important. And this is mostly for lawyers, but it also applies to other advisors or to trustees or to family members. And here's big thing number 6. Stand your ground. You are going to have other lawyers, and I've illustrated this, I think, in the last few minutes. You are going to have other lawyers tell you that if you have mandatory alternative dispute resolution procedures in your documents, they're going to tell you you're an idiot, you're stupid, you don't know what you're doing, you're incompetent, and you're going to fail, and it's going to cost more money. And when they do that, smile sweetly, say, thank you for your kind comments, and then cram it down their throats. You gotta stand your ground. Remove the trustee, remove the beneficiary, apply the terms of the trust as written to enforce the document, which is why, again, those ADR provisions have got to have teeth. So I want to wrap this up here. Thank you for bearing with me while we go through this. Alternative dispute resolution is extremely important in estate planning. It spoils the craft of lawyers who look for families in trouble and will provoke and exacerbate and perpetuate conflict so that they can maximize legal fees. And I know that sounds extreme, it sounds over the top, but there's some amazing books. In fact, go read Charles Dickens' Bleak House, where there was a probate estate that had lasted for like a century, over several generations, and finally ended when what? The lawyers had successfully converted the entire estate into legal fees, so there was nothing left to fight over anymore, so the estate settled. Over and over again, I have seen cases that should have settled that because the document was drafted poorly, or it didn't have teeth, or it defaulted to statute when the statute was inadequate, or it didn't have a mechanism for interpreting, or it didn't have alternative dispute resolution procedures, where the estate gets embroiled in this conflict and it just chews up fees. So people talk about asset protection, and people talk about, oh, I want to not get sued. What are the most likely things to land anyone in court in America? Guess what? The 2 most likely things, they both involve family. Most likely thing number 1 is, guess what? Divorce. Most likely thing number 2 is disputes over a dead person's property. This is not a course on marriage counseling. It's a course on how to design an estate plan to avoid that ugly outcome. Think about what matters most here. What matters most here is not everybody getting their fair share. It's not crafting beautiful trust documents or even getting paid a fee. What matters most are the people and their relationships. And if as a result of our estate planning, the family is destroyed or disrupted, we've done a disservice to our clients. If as a result of the estate planning, the estate is preserved and the family is preserved and comes out stronger and better as a result, we've done a good job. So that's my basic summary. Obviously, I did this off the cuff, so the words were not exactly the same as what I presented to the College of Estate Planning Attorneys. Thank you for listening. If this is helpful to you, if we can help you in any way, give us a call. One of my greatest joys in life is to talk with people that have seen our videos or read some of our articles and come and say, hey, I've got an issue or a question. Can you help me with this? I love to help people fix things. That's why I became a lawyer. So thank you for listening. That's it for now. Rick Durfee again. This is a summary of a presentation given to the College of Estate Planning Attorneys. Rick Durfee for Durfee Law Group, signing off.